Pleased to say that Norman has come back and has joined us. Thank you, Norman. I was introducing you and I don't think you were here. I was saying how much many of us have benefited from your scholarship and your experience over the years, and how much we're delighted to have you here. So Norman will speak. Norman will speak on the limits of law as a weapon in struggle for justice. And I think he will also provide a historical background as he normally does in his speeches. So over to you, Professor Norman Finkelstein.
Well, thank you for having me. I never left. I want that to be clear because I'm pretty reliable. I hope there was some technological problem. And I noticed that Maween and Dina, their images aren't showing up, so there may prove to be a problem with them as well. Just a forewarning. I sat down to write my remarks this morning. Before I do, obviously, I want to express my sincerest sadness and outrage at the murder of the Palestinian journalist. I don't watch social media or actually any media. And so I was not familiar with her name or her image, though I understand she's a household presence to most Palestinians, or maybe to all Palestinians. So I didn't have that immediate sense of personal identification with her. It was only after speaking to many Palestinians that I came to understand how deeply her work and her person impressed themselves in the consciousness of Palestinians. On the other hand, when I heard of her death, the first thing that occurred to me was the Human Rights Council report from 2018 or 2019, I can't remember now which, 2018 or 2019, on the mass nonviolent resistance in Gaza. And one of the conclusions of that report was that Israel was intentionally targeting, the list it gave was intentionally targeting children, medics, journalists, and disabled people who were assembling often quite far from the place where the snipers were, but sometimes as many as 300 meters away. But the Israeli snipers were intentionally targeting those, and of the category, journalists was one of the four categories: children, medics, journalists, and disabled people. That was one of the four categories that they focused on. So not at all to trivialize the death of Shireen, but just acknowledge that that's been Israel's modus operandi for quite a long time. And now let me move on to where I hope I can make a scholarly, that's the right word, a scholarly contribution, namely to look at this whole question of how much energy, how much effort, how much resources should be invested in trying to get an ICC prosecution. I'm going to make, I think, just 3 points. The first point is, I think it's often forgotten or not even noticed in the first place that the Palestinians have already had an excess of victories, a surfeit of victories in international forums. So let's just recall briefly for listeners the victories that they have already achieved. In 2004, the International Court of Justice gave an advisory opinion, in which on all critical points, the illegality of the Israeli settlements, the fact that the West Bank, including East Jerusalem and Gaza, are occupied territories, the inadmissibility of acquiring territory by war, the right of Palestinians to self-determination. The International Court of Justice, by a vote of 14-1, voted in favor of the Palestinians. It was a huge victory. The Israelis dreaded it from the get-go. They debated whether to participate in the proceedings. They decided to participate in the jurisdictional phase of the proceedings, but not to continue during the actual investigation. The Palestinians, as Mouin Rabbani told me at the time, they invested a huge amount of resources in this court case. The orchestration was led by Nasser al-Kidway, and apparently, according to Mouin, he did a brilliant job. The problem, however, is what did the Palestinian leadership do with the victory? It got this paper victory after investing a huge amount of resources, despite huge Israeli resistance. It took the victory and it put it in a drawer, and it closed the drawer to collect dust. Then in 2009, after Operation Cast Lead, the Palestinians scored another huge victory. A prominent self-avowed Zionist and a Jew, Richard Goldstone, based on a mandate from the UN Human Rights Council, he produced a voluminous and deeply scathing report on Israeli war crimes in Gaza during Operation Cast Lead. Once again, Israel dreaded this report. The report contained devastating findings certified by a prominent jurist, a prominent Jew, and a prominent Zionist. What happened with the report? Well, the Palestinian Authority in the UN worked with the United States to sabotage any action on the report. So that was another huge victory that the only remnant of it was for those who printed out the report to collect dust. And now, fast forwarding to the present, there have been a succession of huge victories by the Palestinians because the leading Israeli human rights organization on the occupied Palestinian territories, B'Tselem, as well as the two leading human rights organizations in the world, Human Rights Watch and Amnesty International, which represent a very broad swathe of liberal public opinion. It's not just the authority of these organizations themselves, but the constituencies they represent. They represent global liberal public opinion. They all concluded that Israel is, in part or in whole, an apartheid state. What have the Palestinian authorities done with these victories? The B'Tselem, Human Rights Watch, Amnesty International reports. What have they done with them? As of now, and almost certainly moving into the future, nothing. So, as we look at the possibility of an ICC prosecution, we have to bear in mind that even were it to succeed, which I'm skeptical of, in and of itself, it will be no more significant than all the other victories of the Palestinians, which, as a practical matter, produce nothing. So let's now move to the ICC. The ICC, what's called the International Criminal Court by the West, by non-Western countries is often called the International Caucasian Court, the ICC, because the only persons it has actually prosecuted and convicted have been African leaders. There were a couple of exceptions of investigations that were about to be launched, but those investigations were dropped. And now the one exception seems to be, and this exception will probably proceed for reasons which are so obvious they don't need to be named, namely the prosecution against Russia for alleged crimes in the Ukraine. Now, there have been two cases in the ICC. The first case was referred to the ICC by the Comoros, the islands of the Comoros. I can't recall what their full name is, but the Comoros, because of the Israeli assault on the humanitarian vessels en route, the flotilla en route to Gaza in May 2010, to bring humanitarian supplies to the people of Gaza who were under siege. The Israelis launched a night attack on Gaza, killed originally 9 passengers, but then the 10th died. He was in a coma. Killed 10 passengers, seriously injured scores of others. That case proceeded through the ICC. It was dragged and dragged and dragged and dragged because Fatou Bensouda, the chief prosecutor, she kept trying to kill the case, but there were clearly people within the court who were not pleased with Fatou Bensouda's machinations, and the case kept coming up and up again. It kept on being renewed until finally Fatou Bensouda killed the whole case. Now, I studied that record very closely. I'm probably the only person in the world who's written a book on the subject, just going through the UN case. And it was clear there was a complete and total whitewash. It was a disgrace what Fatou Bensouda did in that case. Now, Fatou Bensouda was coming to the end of her term of office. She was hugely humiliated within the ICC for her whitewash in the case of the Mavi Marmara. The Mavi Marmara was the flagship of the humanitarian flotilla. It was flying under the flag of the Comoros. So they were the ones who referred the case to the ICC. And so she then gave a green light to proceed with the second case in the ICC against Israel. The second case had basically 2 components. It's not the whole case, but basically it focused on it had 2 prongs. One, the Israeli settlements in the occupied West Bank, and 2, the repeated Israeli murderous assaults on Gaza. That was the essence of the second case. And the second case, as I said, Fatou Bensouda gave a green light to proceed with it because she knew that she was leaving office, so she didn't have to bear this albatross. And then it was passed to, I'm not sure if you can pass an albatross to someone, but it was passed to Karim Khan. And there were great expectations for him. I talked with very good experts. Apparently, Karim Khan his grandfather was the chief champion for the Palestinians in 1948 at the UN. And some people assume Karim Khan was the grandson and that he would proceed with the case. I was very skeptical. The ICC, for those of you who don't know, the ICC is not a court. It's not a court in any meaningful sense. It's a political body. It targets all those countries which don't have a major power backing them, and therefore acting effectively as a veto on any prosecution. And it's so politicized. Now, all courts are politicized. Let's not kid ourselves about that. But this court is so politicized that I think it no longer deserves the ascription of a court. So the second referral, as I say, is still in motion, though you might say it's in sedentary motion under Karim Khan. My own view, having reviewed the case very carefully, is the Palestinian case is strong on most fronts. It's very weak on one front. Namely, in the Oslo Accord, it ceded to Israel, it gave over Israel the right to prosecute any crimes committed in the occupied Palestinian territories. That was one of the elements in the Oslo Accords. And so it ceded to Israel the jurisdictional right to prosecute violations of international law. The Palestinian side, so to speak, has tried desperately to finesse that problem. In my view, it's unsuccessful. I have read all the submissions on both sides, and I would say what are called amicus briefs, friends of the court briefs. I would say the Palestinian case is weak. However, on that particular issue. However, having said that, it doesn't really make a difference because the court is ultimately political. If the Palestinians had an ironclad case with no weak links, it would not, and I say this emphatically and unequivocally, it would not in the least change the outcome of the court decision, because this is not a court, it's a political body. And whether or not the Palestinian case is strong or weak wouldn't change anything. So let's now move on to my last point. My last point is the ultimate arbiter, and I don't want to sound like some wild, I'm not Bakunin, I'm not some wild-eyed anarchist or radical, although I do consider myself a radical. I'm trying to be realistic about these matters. And realism tells me this is not about politics. This is not about law. It's about politics. Lawyers, unfortunately, have a very exaggerated opinion of themselves and about the power they possess. Law is an element in the political process, but it's not more than one single element. If I could take one example quickly from my own country, many of you will know the most famous Supreme Court decision in the United States was the Brown decision, which ordered the desegregation of American schools in 1954. So everyone remembers Brown and they remember desegregation. And they put the two together and they say, isn't it wonderful in the United States, the Supreme Court desegregated the schools? What are the facts? In 1965, 11 years after Brown, 2% of the schools in the South were desegregated. 2%. In other words, Brown had next to zero impact on the actual desegregation of the American South. What desegregated the American South? Very simple. It's called the Civil Rights Movement. A mass popular, as in this case, nonviolent movement, forced, F-O-R-C-E-D, forced the desegregation of the American schools. It had next to nothing to do with that Supreme Court decision. So now extrapolating from that, but I don't think wrongly extrapolating or extrapolating too capriciously, unless there's a popular mass movement garnering international support, the second referral in the ICC, the second referral will be buried in the ICC. Nothing is going to come of it. Anyone who believes that simply based on the referral, it's going to have a positive outcome without mass popular support or mass popular mobilization in the occupied Palestinian territories, and then that's supported by international solidarity, in my opinion, it's never going to happen. Now, in my view, and this is purely speculation, I want to emphasize purely speculation, the human rights organizations were hoping that their reports on Israeli apartheid would put pressure on Karim Khan, the current chief prosecutor, to move forward with the case. In other words, they were going to act as surrogates for the absence of a popular movement. So it was very noticeable that the human rights organizations staggered the release of their reports. First was B'Tselem, then about 5 months later came Amnesty, and then about 5 or 6 months later came Human Rights Watch. So my speculation was they were trying to keep up the momentum, keep the pressure on the court, keep it in the headlines, make it impossible for Karim Khan to evade the fact that these human rights organizations were saying Israel is an apartheid state. You better not bury this referral. Whether it'll work or not, I would say I'm skeptical. I think nothing is going to happen despite the heroic efforts of the human rights organizations. So what is the significance? What's the significance of a victory in the ICJ, the International Court of Justice, or the ICC, the International Criminal Court? I say, even if there were a victory in the ICC, and I don't see it, but even if there were one, it's still a paper victory until and unless you use that victory in order to mobilize public opinion. The great value of those victories in the ICC, the ICJ, the great value is they give legitimacy to your cause in the court of public opinion. They are a spectacular weapon to be used in the court of public opinion to mobilize public opinion, to get it on your side. But if you don't even aim, if you don't even have a goal of trying to organize public opinion, they're absolutely worthless. They just collect dust in your drawer. I have here, sitting in front of me, I have thousands and thousands and thousands and thousands of pages of human rights reports, nearly all of which found in Palestinian favor, which all they do on my shelves is collect dust because the so-called Palestinian leadership did nothing with them. Now, if you want to ask what could be done with them, I think the best example is the Zionist movement. Whenever the Zionist movement won a paper victory, let's start with that Balfour Declaration. The Balfour Declaration was 60 words, but there's not a single person acquainted with the conflict who hasn't heard the words Balfour Declaration. Why? Because the Zionist movement made sure you knew those 2 words, Balfour Declaration. It was for them, as Abba Eban, the famous foreign minister, put it, it was their certificate of legitimacy. And the same thing with the partition resolution of 1947. Again, for the Israelis, a certificate of legitimacy. You use it as a weapon in the battle for public opinion to win support. But if you're not using it in that way, if you're not trying to exploit that victory in a court, or in the case of the Balfour Declaration in the UN, in 2 other international bodies, then the victories are worthless. They get you absolutely nowhere. There's this crazy idea in the minds of lawyers, that if you win a court case, you've won the cause. No, you've won something, in my opinion, for sure. But it's only something if you make use of it. If you just file it away in your cabinet, it ain't worth 0. Thank you.